Hey, this is attorney Elizabeth Potts-Weinstein, and today we're going to talk about how to trademark an idea. When we're looking at how to trademark an idea, we first have to look at what do we mean by an idea. That could be the name of a business, the name of a product or service. It could be a system that you've come up with. It could be a recipe, a plan, a project, some kind of invention. There are all kinds of things that you might consider an idea. And how you protect them depends upon what kind of idea it is and how far along you are in the process. An idea by itself isn't protectable. It has to have something else with it. So if it's an idea that's secret, it might be protected under trade secret law. If it's an idea that's a useful invention, it might be protected under patent law. If it's an idea that is creative, it might be protected under copyright law. And if it's an idea that's kind of a branding for something, that might be protectable under trademark law. So if you want to protect an idea under trademark law, it needs to be a word or a phrase or a logo that you are using in conjunction with the sale of a product or service to identify you as the source of that product or service. So obviously that's not going to be every idea, but there are certain ideas that typically are the names of a business, the names of a program, a service that you're providing. It could be the name of your product. It could be the branding that's on the top of your website that you might be able to protect under trademark law. So under trademark law in the United States, if you have an idea that you might want to protect under trademark law, typically, if you're calling it an idea, you haven't actually launched the business yet and you haven't made any sales. So if you're not using it in conjunction with the sale of a product or service, how do you protect it? Well, what you do in the United States is you can file an intent to use trademark application. And that is an application for something that you intend to use, and you will say under penalty of perjury that you intend to use this in commerce, but you're not quite using it yet. So the benefits of an intent to use trademark application is, number one, you get to find out if you're going to get the trademark. Maybe it seems like a great idea and it seems like no one else is using it, but you can't get it through the Patent and Trademark Office to get approved. And you'd much rather know that now than after you've already created a website and done all the branding and started making sales. There are two problems with intent to use applications. Number one is there are a little bit more fees, and that can be an issue for some people who are on a tiny budget because the initial fee is the same, but when you file some other documents such as your statement of use proving that you actually use this trademark in commerce eventually, and also any extensions you need for more time, that's going to cost you more money every time you do it. The second issue is if you intend to use a trademark and you're not using it already, and it's just an idea, it's not set in stone, you might change your mind and be tweaking it a bit before you actually use it in commerce. The danger is if you change the design of that logo, if you change the words that you're using in your branding, then your trademark application doesn't count because you applied for a trademark under one thing and now you're using something else, even if it's just a tiny bit different. And when I say a tiny bit different, I'm talking about very tiny changes. Like, let's say you decide instead of having two words to smash the words together with no space. That's too much of a change. Let's say you use a dash in between. Let's say you change the spelling of the words. All those things, all those changes to your branding means that you're not going to be able to declare that you use it in commerce because you use something different than your initial application. The bottom line is if you have an idea that you want to protect under trademark law, the first thing you need to do is a search. You need to search on Google, you need to search in the trademark database, you need to look for other domain names, search on Amazon, all kinds of places to see, is anyone else using that exact trademark and also other things like it. And I talk in another video that I'm going to link above more details about the kind of search that you need to do. You want to know if someone else out there is using that trademark so you don't waste your time and money in developing it, and also so you don't get a cease and desist letter from some person who already had dibs on that idea. Again, this is Elizabeth Potts-Weinstein. If you have any questions about protecting your ideas, feel free to go ahead and ask them below and I'll try to point you in the right direction. If you found this video helpful, hit that like button and subscribe for more tips about trademark law and business law generally. Thanks a lot for watching. Bye-bye.